Clause 10, page 11, line 14, at end insert at an abortion clinic.
My Lords, I rise to speak to the amendment moved in the name of my noble friend, Lady Sugg. And obviously I'm not going to repeat the comments that were made at the report stage, but given that these are helpful amendments in terms of tidying up and administrative amendments, I think it's appropriate just to put on record the very serious concerns I have about this particular amendment, Clause 10. I still have reservations about the sui generis nature of the proposal, and particularly, my Lords, the use of the word influence in Clause 10(1)(a). I do think this is an extremely slippery slope, including this particular subclause in the legislation, and I think it will come back to haunt this House and the government in due course, not least because I do believe that this particular clause is unnecessary. It is in fact legislation by anecdote and a knee-jerk reaction to lived experience rather than empirical evidence, not least because there is existing legislation in place, not least, as I mentioned before, PSPOs, which incidentally don't work, and the two most notable cases raised in the debate earlier this month have resulted in no criminal action and the dismissal of the cases because the threshold for criminality and prosecution was not met in these unique cases of the Minister of Religion and the Christian activists affected by those cases. So very briefly, my Lords, I think the clause will result in stigmatisation, hostility towards, and eventually the criminalisation of one group of people, which is Christians. I don't think that is what the vast bulk of your Lordship would wish to happen. I think the clause is pernicious and fundamentally an assault on freedom of both speech and thought. And although it cannot be stopped, and this bill will get royal assent, I do think it timely and appropriate for some of us to make the case that this is bad law. It is stigmatising a small group of people who are not fashionable, and it will come back to haunt us all in due course, those of us who care very deeply about freedom of speech.
My Lords, I rise very briefly to support what my noble friend has just said. I am grateful, of course we all are, to Baroness Sugg, who has made a genuine effort to improve things since the first time she moved her amendment. And that is something that should be acknowledged, and is acknowledged, I think, throughout the House. But, my Lords, we are, as my noble friend Lord Jackson said, potentially on a slippery slope here, because the stigmatising of someone who privately prays doesn't necessarily say anything at all is very dangerous. If we were debating what happens in other countries, as we sometimes do, this is a long way off Chinese practice, but it's going in that direction. And I do think that we should be very, very careful. I think the law as it stands, without this Clause 10, is adequate to deal with any problems that might arise. And I concede that they might from time to time. But I do not believe that the sledgehammer to crack a nut approach is the right one. As my noble friend said, the bill is going to go on the statute books. It will accompany many other imperfect pieces of legislation that we really should not have allowed through your Lordship's House.
I want to say three things. First, to pay tribute to the noble Baroness